All right. Good afternoon, everybody. Welcome to the House Committee on Government Operations and Military Affairs. We are here this afternoon to take up the annual technical corrections bill. So thank you. Welcome.
Thank you. So for the record, Anthea Dexter Cooper from the Office of Legislative Counsel. Pretend that I have like 20 other people sitting behind me who also worked on this bill. So you have posted to your committee page for today 3 documents. One is the bill. It's 457 pages long. If you don't want to read the 457-page bill, there is a 30-page summary. I'll talk about the summary a little bit. And then what I was going to do was go through like 2 pages of just some like highlights. There's a document of the highlights that I'm going to go through just so you can see examples of the sorts of things that get changed in the technical corrections bill. When I've talked about this bill in the past, in the first year of a biennium, you may remember I like parted in this like box of books, and I talked about how we go from the green book to the green book with the supplement to the green book with like the out of the book supplement, and then it gets combined and reprinted. So the volumes that are getting reprinted in any given summer, we do 4 volumes, and some titles are split between 2 volumes, and some titles share a volume with another title. Those are the ones that are more heavily represented in the bill. So you will see a lot of language in this bill related to Section 30 and huge chunks of Section 20 of Title 21, which is the title on labor, that are being rewritten, updated for clarity, fixing citations that are wrong. When I was going through the language that Damian Leonard provided me with for Title 21, I asked him like, why he finally did this. So there are at least 2 people that are excited about the fact that he finally did this. 3, I guess I'll include myself. But I asked him like, Damian, why can we make this change as a technical correction? He's like, oh, well, that board no longer exists, and the last person who was on it died in 1980. So like those are some of the things that we're doing in the technical corrections bill to like update long neglected statutes. If you're looking at the, I guess it's 31 pages summary document, I think the most important pages are the first page and the top section. It gives you the overview of the sorts of changes that are made in the technical corrections bill. It tells you what titles are most heavily represented in the technical corrections bill, given what volumes have been replaced. And then the last page of the summary is going to give the section ranges for each title. And it's going to give you the name of the attorney or attorneys who you should contact if you have a question about the section. This is a really useful tool if you get questions from your colleagues about a particular section, maybe unrelated to the technical corrections that are being made there, but just about the substance. None of the changes in the technical corrections bill are substantive, and lots of us will send the language over to the departments or the agencies that are involved in the title just to get confirmation that nothing is going to have any sort of unseen effect in terms of implementation or interpretation, and to confirm that they really are just technical corrections. So if you go to the bill, and you can stop me when you get bored, and then I have a couple facts that I'm going to give you at the end, but I'm going to run through the 2-page document and give examples of some of the things that are getting changed as technical corrections. So the first one, Section 33, this is correcting a cross-reference to a subsection. A lot of times when we amend statutes, we add a new subsection in the middle and then redesignate the remaining subsections and don't necessarily catch all of the other places in statute that reference it. So this was a reference to subsection E. A new subsection was added. So what was subsection E is now subsection F. So correcting that change. That's page 18, line 3. Next one I'm going to highlight just a little bit down, Section 34. The Armed Forces of the United States now includes the Space Force. So we're adding Space Force to the definition of armed forces in the United States in a couple places where it had not previously been changed.
Representative Hango.
I have a question about that because I actually have a bill that's in to do that. So is that bill necessary?
So I think I know about your bill. It's to make an amendment in Title 16, right? Yes. So you will see Section 34 is amending 16 VSA Section 2537B4. I believe it is fully absorbed your bill.
Oh, yep, great. So the bill doesn't need to go anywhere.
Check, done.
And Damien worked with Beth to confirm that we were putting Space Force in the same place in the list to make sure that there wasn't any
Mhm.
unintended need to harmonize the language if both bills do move.
Right. Does somebody complete the circle with the committee that has the bill on their wall to let them know that it's not necessary, like to incorporate in a miscellaneous ed bill or something like that?
So what will happen is the attorneys that have been involved know, Beth knows that this language was included in the technical corrections bill. If it does end up, this is such a good example, if it does end up in the bill, there is language, the second to last section of the technical corrections bill is to account for what happens if there's a bill that doesn't perfectly align and the substantive bill will take priority over the technical correction. And if the technical correction can't be made consistent with the substantive bill that moves, then the technical correction is sort of forgotten. So let's pretend that the technical correction is making a change to a subsection and a different bill that moves deletes the subsection. There's no point in making the technical correction in the subsection that no longer exists in law. So we just don't make the technical correction.
Thank you.
It's helpful that you were here and knew your bill so well.
I think you're a visionary. Saw that in.
Sure. Okay, my next example is going to be section 36. This is adding a subsection heading. If we have subsection headings, that's when you have like a few words or a full sentence and then a period in the beginning of a subsection or a subdivision heading. You need to have it for all of the subsections or all of the subdivisions. So a lot of times we'll delete a subsection if it's the only subsection, or in this case, add a subsection heading if it was the only one that one was missing for. I'm now going to jump to section 54. If you're following along, this is going to be on page 23. In 1 VSA section 128, we talk about how we use the word person, not people. And if you look at the definition of person, it is more encompassing than just like a human being, like corporations fall under the definition of person. So where possible, we use individual if it's talking about a human, and we would never use people. We would say two persons, not two people. It's just how we draft. So that's correcting that. Section 55, when you have a list and the items in the list are not complete sentences, then there is not a capital letter at the beginning of it. So if it's a list that's going to have semicolons at the end, that subdivision or subsection should not start with a capital letter. So that's making the change here. Also, one of the things that the editors have started doing, this is on line 13, is when there's an internal cross-reference to like another section within the title, the chapter, the subchapter, using the narrowest reference. So if you're saying, let's pretend you're talking about, I'll use this example, you're talking about something in you're in section 5212, so 5212, and it's referencing another section in that subchapter, like 5217A1. You would reference the subchapter. So this section or this subdivision in that same subchapter. If you were citing to 18 VSA section 1, you would say section 1 in this title because it's in the same title, but it's not in the same chapter or subchapter. So using the closest link, the narrowest window that you can get to in statute. Section 67, this is going to put you on page 33. This is eliminating some superfluous language. We're now into the Title 21. We're into the Damian Leonard corrections. You'll see on lines 20 and 21. This is a federal act. It became a public law, like if we were to say 2023 acts and resolved number blank, that in and of itself is telling you that it has been enacted by the Vermont General Assembly. It is not necessary to say that that public law was enacted by the Congress of the United States of America. So it's superfluous. We don't need it there. I'm going to jump down to section 77. Lots of changes in this one. On page 46, line 15, you're going to see a superfluous of Vermont. When we say state and it's capitalized, that is only referring to the state of Vermont. If state is lowercase, it could be any state. So saying state with a capital letter of Vermont, not necessary to have Vermont there. On line 21, 20 and 21, you'll see that there's a reference to the effective date of this section. That's not very useful to have in statute. It might have been very useful to have when the bill was moving back in 2010, I think, to say this section shall apply on the effective date of the section, or anything that happens after the effective date of the section, because you don't yet know when it's going to be effective. Maybe it was going to be effective on passage. But then for the reader looking at that, you don't know when you look at 21 VSA section 306, when the section was effective. So substituting June 3rd, 2010 for the effective date of this section. You'll see that change a few other places. Not a ton, because we try and avoid it when we're drafting, but it does come up. Now I'm going to jump all the way to section 110. This is going to put you on page 81 at line 9. And you will see a change from the word will to shall. In our drafting manual, we try not to use the word will. We don't say this agency will do something. We say this agency shall do something. We're telling them to do it. You shall do this. Will maybe gets a little bit more into the, well, they might do it. They will do it in the future. So we try and be consistent. We use the word shall. So changing the word will to shall. I am frequently asked in the other body, what is my favorite technical correction? So this is my favorite technical correction, and it is a relic from a definition of vending machine in our title on labor to tobacco vending machines, because you used to be able to buy cigarettes in vending machines. And I can remember as a kid there being vending machines that sold packs of cigarettes, and that is not something that our statutes reflect now that you can't sell cigarettes through vending machines. But this definition of vending machine in Title 21 is not hip with the times, and you would be updating it.
I remember the one at the YMCA.
Ashtrays and elevators. Yep.
Or on airplanes.
Batches left in
Doctor's offices.
Sorry, we digress.
It's totally okay. It's 1:15 on a Friday. Digression is good. And I'm, sufficiently trying to bore you. Okay, so section 116, this is going to be page 85, line 13. This is changing the use of U.S. when it's a modifier. So you wouldn't say United States Congress, you would say U.S. Congress, because United States is being used as a modifier there. You wouldn't say states of the United States. That wouldn't be states U.S. That's not the modifier to the states. You would say United States of America, U.S., and that one, And then next to this is an example of changing an incorrectly capitalized state to a correctly lowercase capitalized state. So public body means the United States Congress. Any state legislature, that shouldn't have been a capital S. That would be saying only you legislature, not any state legislature. We are now going to move to section 121. We're going to be on page 94, line 10. A relic from how we drafted is if we were talking about something within the state or without the state, using without as a way to say outside of the state. That's not really how we use the word without anymore. So we would be saying testimony of a person outside the state, how that testimony would be taken. Gonna jump to section 138. This is I think, really good example of eliminating legalese, the here and after, therefore, heretofore, all of the different iterations of those, to use language that is not only easier to understand, but more useful to the reader. So this section said, prior to this proposed amendment, an award of the commissioner shall, in the absence of fraud, be conclusive between the parties, except as provided in section 668 of this title, unless an appeal is taken therefrom as hereinafter provided. How are you going to know what sections of law to look for to know if the appeal is taken as hereinafter provided? So Damien has helped you out, dear reader, and instead it says, unless the award is appealed pursuant to section 670 and 672 of this chapter. So telling you which sections right around it, they're the section right after this one. The reader probably would have found it, but it's more helpful to, instead of say, therefrom is hereinafter provided, to give the sections that are applicable. I'm gonna jump to section 158. Page 129, lines 2 to 4. This is correcting the name of a federal act and the citation to that federal act. Section 162. A lot of things are going on here. An article that is missing is added on line 20. It's providing clarity to a time period. You'll see a lot of instances in statute where something needs to happen within 30 days of something else. Is that the 30 days before, or is that just the 30 days after? So you'll see a lot of ofs being changed to after or following in that instance. Correcting verb tense, we drafted an active voice, and correcting the spelling of the word canceled. Pop quiz, how many L's does cancellation have?
Two.
How many L's does canceled have?
One.
Yes, but if you're in England, it has 2. So there are lots of instances of canceled being spelled with 2 L's in statute, trying to get rid of them.
Since we're in New England, is it?
I don't think so. Chicago Manual of Style and our editors would say 2 L's in cancellation, 1 L in canceled. Okay, I think these next 2 sections are exciting. I'm probably the only person in the room who does. Sections 210, section 210 on page 239, it says a person shall not willfully and intentionally. When we draft, willfully and intentionally have the same meaning, and we don't use willfully, we only use intentionally. So changing it to just say a person shall not intentionally make a false statement. And then in the next section 211, it used willfully, but not willfully and intentionally, and it probably always should have just been intentionally, using the correct measure of intent. And this is something that our judiciary team, when they give us CLEs on drafting in the criminal laws, are always good at telling us which of the intent words we're supposed to be using. Section 214. This is going to be correcting some terminology on administrative rulemaking. In Vermont, we adopt rules under the Administrative Procedure Act. Higley is involved in that process. We do not promulgate regulations. I know it sounds way more formal and important to promulgate regulations. That's not what we do under the APA. We adopt rules. And then this also, just in the section heading on line 11, it's saying general penalty civil. It isn't actually a civil penalty, it's an administrative penalty, and you'll see that on line 14. So correcting some terminology there. Going to jump to section 244. This on lines 10 and 11 is changing how we reference an age. If you're talking about someone who is under an age, in this case under age 16, we would say under 16 years of age. So this is to conform with the balance of how we draft statute under our drafting manual. Going to jump to section 259. You've seen examples of this before. This is one of those 30 days of being changed to 30 days following. We have not in all instances changed one of those dates, the days of, to be following or after. There are a couple, and then I asked the drafting attorney about where they said, well, this is something that could happen before. You have a window around a particular date. So before a petition is filed and a point of time after it was the example that came up there. So you will still see something happening within days of something, not just days following or days after. And you'll also see something needing to happen preceding too by a time range. You'll also on page 294, line 1, talking about the Joint Fiscal Committee of the Legislature under our drafting manual. And to be consistent, we call you the General Assembly, not the legislature. You are the legislature, but we call you the General Assembly. So the Joint Fiscal Committee or the General Assembly. Jumping to section 277 on line 10. Another one of those where you're talking about like the effective date of this act or the effective date of this section. This was an instance where it says revenue from the fee increases specified in this act. How do you know what act is this act without then going and looking at the history of the amendment that added this section? We are helping you out by actually telling you what the act is. It's 1990 Act and Resolves number 286. Section 278, just a little bit further down. This is an instance of getting rid of gendered language. We do not in the ordinary course add things to the technical corrections bill just because it has a gendered pronoun in it. But if we are amending statute, we will get rid of the gendered language. It is not, contrary to what a lot of people think and what would be way easier, as simple as changing he or she to they or him or her to them, because those are plural pronouns in grammatical purposes. So we usually have to find a way to draft around it. That's why you'll see a lot of repetitive language. The commissioner shall do this, and then you wouldn't then say he or she, you would say the commissioner, the commissioner, the commissioner. This is also an example on line 19 of where we can use individual as opposed to person. We're talking about driver's licenses here. A corporation doesn't get a driver's license. When we're talking about driver's licenses, driver's license is DRIVER''S. It is the license belonging to the driver. It is not a driver license, and it is not a driver's plural license. So I think with this bill, all of the driver's licenses will be correctly apostrophe.
Yes. Thank you for the grammatic deep cut.
See, I would have thought that given your years of work on transportation bills, that would have been your favorite technical correction.
Well, possibly, but I feel embarrassed that we didn't change them all the last time we went to 23. We didn't change the commercial driver's licenses ones. I won't bore you with what the holdup there was, but everyone is in agreement, commercial driver's ''S license.
I feel bad driving home tonight.
Section 298, we are correcting terminology for changing a fine to a penalty. If something is, hold on, let me make sure that I actually have the right one here. Page 316, line 12. Yes, you are not fined unless it is criminal. If it is a civil penalty, you are assessed a civil penalty. If you are talking about something that is $25 and there's no term of imprisonment, that is not a $25 fine. That is a $25 civil penalty. So we've been trying to catch those in technical corrections bills and just drafting in general. Jumping all the way to the 300s, section 326. Redesignating some subsections that have been repealed for a long time. So what we do when we repeal a section or a subsection, we put after it that bracketed repealed that you'll sometimes see in statute. Once it has been repealed for a long enough time, don't ask me how long, till it feels right. You could put new language in that subsection or new language in that section. The idea being that if you wait long enough, there's sort of not this confusion as to like the reference being to the language that used to be there. These subsections have been repealed long enough that when it was being reordered, the drafter, the attorney who works on the title, wanted to sort of streamline the section a little bit. So still repealed language. Expectation is that it won't cause any confusion, and this way you don't have like gap subsections within the section itself. Section 332, this is deleting some obsolete language, and I think we could also say deleting some just incorrect language. There used to be a definition for absconding that was in 28 VSA section 724 D3. The definition was deleted, so there's nothing that comes after means. It just says, as used in this subdivision, absconding means, and then it stops. And there's nothing after it.
Awesome.
So you are deleting the as used in this subdivision. Similar in section 333, there are definitions for 28 VSA section 808C in 28 VSA section 808D. 808C has been repealed, 808D just didn't get repealed. We don't need the definitions that are applicable if the section itself is. Almost done. Section 334, this is an instance where we have a subsection heading, and it's the only one where there is a subsection heading. And we need to have them either for all of the subsections or none of the subsections. In this instance, deleting the one lone subsection. And then on line, page 335, lines 7 and 8, corrected both the name of a fund. This fund had its name changed, I believe in the big bill last year, and this is just a place that the fund name was not caught or it needed to be changed, along with the applicable citation. So that's being corrected. Section 335 is another one of my favorite sections in statute. As much as lawyers might want to, we do not, when we draft, say things like including, but not limited to. Under 1 VSA section 145 and Supreme Court cases prior to that, saying including does not require but not limited to, or but shall not be limited to, or anything like it. It's not necessary. it can create confusion if we have it in some places and not in other places, getting rid of it in accordance with one VSA, section 145. Section 364. This is on page 358, line 6. Being consistent with our drafting manual wants to reference 3 VSA chapter 25, that's the Administrative Procedure Act, when there is something related to a requirement to adopt rules. So this is an instance where the terminology is correct. You see that the PUC shall adopt rules. It's just we don't normally give the range of the Administrative Procedure Act. We give 3 VSA chapter 25. And if we were giving the citation range, we would not be using just those 2 sections. The Administrative Procedure Act, as Rep. Pigley knows, is much longer than just section 803 and 804. So correcting the citation and conforming with how we typically reference the APA. 2 more sections to go in my highlights. Section 414, internet no longer needs to be capitalized. Internet is lowercase now.
It's not a thing,
I mean, it's a thing, but I think it's enough of a thing that it's no longer a thing.
that big of a thing.
Yeah, it's like a small thing. So yeah, internet will no longer be capitalized in statute, and we are lowercasing it where we see it. There was a discussion amongst the editors over the summer, and yeah, internet no longer capitalized.
No longer the capital I internet.
Have to remember that one for the weekend.
Okay.
Yeah.
That seems substantive to me.
This weekend.
I know, I really should have just ended on that. Section 464, but there are a bunch of changes in it, one of which is correcting terminology for administrative rulemaking. I'm done boring you with things from sections, so I'm just going to give you some facts about the technical corrections bill this year. 13 attorneys, 16 if you include your very own House clerk, and former attorneys contributed language or items to have me draft for inclusion in the technical corrections bill. 6/7, so 6 out of the 7 people who work in drafting ops either edited this bill or formatted it or did keyword searches and proofs. It is the longest by pages and shorter by sections than your 2022 technical corrections bill, which had 600 sections in it. It eliminates 30 forthwiths. As much as you like to message your actions forthwith, most people don't necessarily know what forthwith means, so we try and use a less legal term. It gets rid of 300 plus instances of gendered pronouns, and it adds approximately 20 conjunctions to formerly unproperly conjunctioned lists. We always have a conjunction and or after the penultimate, the second to last item in a list. And now, if this bill moves forward and is enacted, 20 of those lists will be properly conjunctioned that aren't current. Happy to answer questions about any of the 457 pages or refer you to the attorney who actually can answer the
Mr.
subject.
Chair, I'm a little surprised too that Anthea chose vending machines selling tobacco, not a transportation issue, because I believe last year hers was turnpikes
I did.
and throughways.
Yeah.
Yeah.
I like the ones that have a little bit of a story to them as my favorite sections. And thank you for remembering the turnpikes and the freeway.
All right, so cognizant of the fact that we probably would benefit from getting this moving sooner rather than later. So I'm trying to think of how, if our custom has been to leave this for a couple of days, get it onto the schedule for some time when we have a bit of a window next week, assign a dutiful reporter and try to get this thing out next week, unless anybody finds something over the next few days that our 13 attorneys and 6 drafts people and our dutiful clerk might have missed in this 457-page technical corrections bill, but I have a lot of faith in that.
It's even on a secret. If it got missed in this technical corrections bill, there's a bill that'll come next year where it'll suggest the correction.
Yeah,
It's an ongoing
it's
conversation.
the green books are a living thing, and I like that. Okay, does anybody have any other questions for Anthea?
Now that plan sounds good.
We will look at when you're already booked for next week and try to get this thing on its way.
Thank you so much. Everyone in the office appreciates the fact that you allow us to be your committee bill and give us a place for all of our nitpicky corrections to live.
We really, really appreciate it. I mean, I know we always have a lot of laughs and it's fun to think about, but it's really important that the law be updated and that it be clean, and it takes an enormous amount of work. And so you get to come in here and dump this complete thing with all of these corrections on it. We just get to go, okay, that all looks kind of good, thanks. So thank you so much to you and your colleagues for all the hard work. that you do.
Pass it along to our staff meeting on Monday. Okay, thanks everyone. Have a good weekend.
Thank you too.
All right, committee. A couple of us have a meeting at 2. And I know there are lots of drafts and conversations going on around. Representative Merwick, you have a few minutes here.
Before we get too far away from this, I just want to remember that when Rob was on this committee, he presented the bill. And I think he began it with a threat to read the whole bill.
Yeah, he did.
That's
That's right.
Don't make me,
You guys want me to read it all? I will. Yeah.
Just to put that, in the hopper. So this one's what, 400 pages?
Or, yeah.
4 and change.
Well, I thought for whoever volunteers to do this, I'm willing to sign it to somebody, but if there's anybody who wants to do the technical corrections, GovOps piece, we could also assign it to somebody who doesn't happen to be in the committee today if we really wanted to have some fun. If there's anybody who really would like to do it, I mean, I think there's an opportunity here to explain a little bit about how this stuff works to some of our colleagues. And also I think Anthea did a great job of sort of making it exciting with the numbers. She was doing this.
If you took her summary at the end,
I want that stat sheet for whoever does that at the end, so that we do.
Oh,
that's what I was thinking.
Totally, like you could
Very
actually
interesting.
add some personality.
I'll do it if you want.
You want to do it?
I'll take it to the team.
That's great.
Sure.
I'll work with you on the content.
All right.
We'll make a little sideshow out of it. Yeah, all right.
Maybe we can use humor instead of threats.
So
There's a
lot, I mean, for
Little vaudeville show out of it.
vending machines to Space Force.
Yes,
To
Space Force
the
has-
how to pluralize drivers or not, there's a lot to work with.
There's some material.
Yeah, there is.
We could also remind
Call me
people,
tomorrow after you've had.
there will be a test on this.
I like that. There'll be a test.
Yes, yeah. There you go.
Well, as an Elkhart member, I'm upset that they're removing promulgate and just
Promulgate, yes.
adopt.
Every 4th one makes me sad.
We see it on the floor, though. I mean, it's
Yeah.
not the end of forthwith. It's
Take it
a
off the
functional
floor.
word nor why. It's just
Filibuster.
Losing all our time.
the body does love a good forthwith.
I do.
Sometimes the forthwith is probably superfluous, but sometimes it's about like saying that something has to be done quickly, right?
Yeah.
But what are they using instead?
It's not redundant.
Yeah.
You get it done. On your own, that's how you get it done.
Like you were doing another one the other day. What was it? Ooh.
All right. All right, is there anything else the committee needs to get on the record before we break? So I will see everybody, we'll be, back on Tuesday with the usual stuff. I know a number of people are working on various projects to try to advance things. We'll have an agenda out shortly. I think we're pretty close. Yeah. Okay, so look for that in your inbox. With that, we'll adjourn.